right. Welcome everybody to our 1031 exchange training today. Susan Burns comes to us by virtue of Orange Coast Title with Kim Wilburn, and she's introduced us to Susan, who works for JLM Corp. And Susan's going to walk us through what 1031 exchanges are and what the process is. And so I'm going to let Susan take it away. If everybody could mute themselves, so because this is being recorded, it will be really helpful for the playbacks. Thanks so much. Take it away, Susan.
Thank you. My name is Susan Burns. I'm the exchange officer for JLM Corporation 1031 Exchange. We are a wholly owned subsidiary of Orange Coast Title Company. I believe that Kim's going to get you copies of this presentation. She'll send those to you via email. And this first page that shows our lovely building here in Santa Ana has all my contact information. If you have any 1031 questions or you have clients with 1031 questions, please feel free to reach out. I'm happy to help. So what is a 1031 exchange? It was named after the code section from the Internal Revenue. It allows a party in a qualified transaction to sell real property held for business, trade, or investment. The most important three words you can take out of this presentation are property held for business, trade, or investment. This is not for primary residence, secondary homes, vacation homes, things like this, just business, trade, or investment. Allows you to defer your capital gains by purchasing a new property for business, trade, or investment within the applicable time frame. Why should your client exchange? Their capital gains, especially at this time, are probably significant. It allows them to reinvest in a new replacement property and leverage those dollars otherwise spent on taxes, so they can increase their investment. It also allows for non-income producing property to be replaced with income producing property. So your property is in an area, the rental market has died down, you're having trouble renting and getting quality applicants in, you can sell that property and reinvest totally tax deferred into a property in a better rental market. It also allows the taxpayer to diversify their portfolio and minimize risk. So choosing your qualified intermediary, what do they do for you? They don't simply just hold your money. We're here to guide you through each step of the exchange, ensure you're following the regulations. We work with all your professional advisors, your CPA, your tax attorney. We remind you of important deadlines. We're here to answer your 1031 questions and hopefully simplify the process for you. Most of all, yes, we are here to protect your funds while you're waiting to reinvest. So it's important to note, and I just went through this morning with a potential exchanger and also his agent. It's important to note that qualified intermediaries, unlike title, realtors, escrow, they are not, now the word just went out of my head. I'm so sorry. They aren't regulated. So I've come up with some questions that are important to ask when you're interviewing to hire a qualified intermediary. You want to know how long they've been accommodating. JLM has been successfully accommodating 1031 exchanges since 1988. You want to know where they're going to hold your funds. It should be in a trust account for your benefit. Do they invest exchange funds? The answer should be no. You don't want somebody day trading your exchange funds while you're waiting to reinvest. Do they maintain fidelity coverage to ensure against employee theft, embezzlement, or misappropriation of exchange funds? Yes, and they should have insurance to cover your transaction. again, the policy limit for their errors and omissions coverage should cover your transaction. Ask for copies of their insurance binders, and don't just ask for the binder, ask for the contact information of the insurance agent, because you want to make sure that their coverage is still in force. All they have to do is make one payment to get that binder sheet. You want to make sure that their coverage is still in force for you. I'll make sure I've got the right thing here. So what are the requirements in 1031 exchange? I get this a lot. Again, we're going to go through those three words: trade, business, or investment is how you need to be using this property. The property purchase must be or equal or greater as the value of the property sold. I just spoke to someone again today. They thought they only had to reinvest the capital gains. No, it's sale price or greater minus allowable expenses. There's also a rumor out there that you need to reinvest it $1 over what you relinquish. That is not true either. It is sale price or greater minus allowable expenses. It's important to note that if you have a loan on your property, you can't simply just have that loan paid off in the process and not reinvest those funds again. That's why I say sale price or greater minus allowable expenses, because it includes that loan. What are the most common allowable expenses? The broker fees. You can subtract that off the sale price. Your escrow closing costs, and also your exchange fee can be subtracted off the sale price to come to a net reinvestment amount. Also, the proceeds must be transferred to the accommodator to avoid constructive control of the funds. The IRS does not allow the money to go to the seller after the transaction is over. Any money that goes to the seller is taxable. Just a few quick terms. The relinquished property, when we talk about the relinquished property, we're talking about the property they're selling. The replacement property is the property they are purchasing. Qualified intermediary has many names: qualified intermediary, QI, 1031 accommodator, a 1031 exchange officer. And then boot is an interesting term. Don't know where it came from, but it refers to cash, taxable cash out of the transaction. So if they don't completely reinvest, whatever they don't reinvest is taxable, and that is considered boot. Setting up the exchange. We like to set up the exchange at least a week before closing, just to make sure that everything is ready so that when their transaction closes, the money can come to the exchange. So we like to prepare and sign the exchange documents prior to closing. The qualified intermediary, again, holds the funds. The taxpayer may not control funds. Now, when we say that, the taxpayer can ask us to send their earnest money for their purchase out of their exchange funds. We can't pay for any inspections or any work being done to the property out of exchange funds. That's not allowed, but we can send earnest money. And the funds, of course, should be held in a trust account for their benefit, which with JLM they are. A vague term in 1031 exchange is like-kind property. I hear back so many definitions of like-kind property. Boiled down, it simply means real property. So you're selling a piece of real property, a house, a piece of land, a condo, whatever that is, you can reinvest in real property. Must have a parcel number, must have a legal description. You can even buy a percentage of a property. I have people that exchange into a percentage of property with somebody they know or somebody they're related to. You can buy just a percentage of property as well. It needs to be held for, of course, in investment, business, or trade. It also must be located within the United States. We can't sell a property in the United States and purchase a property in Mexico or in Canada. So what is not lifetime property? As I mentioned before, primary residence does not qualify for 1031 exchange. A vacation home that you only use does not qualify for 1031 exchange. You can buy a property and use it for short-term rental, like a VBRO or Airbnb. You also can stay in that property and use it, but only 14 days out of a year. Also, stocks, bonds, and partnership interests were taken away in 2018. The time frames in 1031 are very strict. You have a total of 180 days from the day the deed records on your relinquished property. You have 180 days to close on any and all replacement property. Now that sounds really fantastic. However, the first 45 of that 180 days, you need to identify property for purchase. That's a very strict rule. There are no extensions. So it's good to keep in mind that you want to make sure, even prior to closing on your relinquished property, you can be looking for your replacement property. You can also go under contract and into escrow with your replacement property. You just can't close on it prior to closing on your relinquished property and still maintain a forward exchange. There are no extensions. Even if the deadline falls on a weekend or a legal holiday, you have to close on your replacement property the business day prior to that holiday or weekend. So the 45-day identification period, within that 45 days, you must turn in to the accommodator in writing an identification form that we provide listing property that you're interested in purchasing. That must be in writing, and there are limits on delivery. They need to be time-stamped. So you're talking email or fax. I have also, because it's time-stamped, gone ahead and sent a DocuSign to the exchanger. If they're kind of close and they don't have a way to scan or whatever, I'll fill it out based on the information they've given and send them a DocuSign to sign, because that is time-stamped as well. So there are also 3 rules when identifying property. The first and most common rule, you may list up to 3 properties regardless of value, and you only have to purchase one of those properties. The second most common rule is the 200% rule. You can list as many properties as you like, as long as the value of those properties does not exceed 200% of what you relinquished. So you sell at $500,000 and you can list $1 million worth of property. The last rule is the 95% rule. You can list as many properties as you like. However, you're responsible for purchasing 95% of the value of what you've listed. So you want to be very careful. We like to offer our services to review anyone who feels they're listing in that 200% rule, just to make sure that they didn't go over. I had a gentleman that went a penny over, put him in the 5% rule, and thankfully we caught it and he was able to adjust his form, and so he ended up that he only had to purchase the one property because he maintained the 200% rule. So the 180-day exchange period, as we said, you must close on any and all. I'm sorry, my light is on a timer here. There we go. You must close on any and all replacement properties prior to the expiration of the 180-day deadline. So you need to close on the business day prior to a weekend or a holiday so that you don't exceed the 180-day deadline. I also like to encourage people to give themselves a little bit of cushion, because things could happen outside of your control that can keep you from closing on time. We had a major wire platform down a couple of years ago, and unfortunately, if you can't wire money, you can't record. And so the gentleman ended up closing on day 181, and he failed his exchange. He petitioned the IRS explaining that a major wire platform went down. The IRS responded that he should have planned better. He shouldn't have waited until the last day. So you want to give yourself a little cushion just to take into consideration things that you can't control. So the financial requirements: to be totally and fully tax deferred, the exchanger must exchange equal or greater in value, equal or greater in equity, must invest all net proceeds into the replacement property. The IRS, as I stated before, does not allow for debt relief in 1031 exchange. So when you sell a property and you pay off the loan, you are not taxed in a normal transaction on the payoff of that loan. In 1031 exchange, you are. So that's why I always say the best formula to use is sale price or greater minus allowable expenses. The same taxpayer requirement. How the taxpayer relinquishes their property is how they have to acquire their replacement property. There are exceptions to that rule. The disregarded single member LLC and sole member or a living trust. Generally, they can't borrow in those entities, and so they need to purchase in their individual names in order to get a loan. The IRS takes that into consideration, so they can relinquish in a living trust or an LLC and purchase in their individual names. And then after the transaction completes, they can go ahead and transfer that property or deed that property back into their LLC or their living trust. Also, if a taxpayer dies during the exchange, the estate or trustee can complete the exchange. Related party transactions. I just want to convey that these are scrutinized by the IRS. They've had issues before with related parties. And so you just want to make sure that obviously there are legitimate, your brother has a property, you've always wanted that property, he wants to get rid of it, you want to buy it from him. If you do a related party transaction, you just want to make sure that the rest of your transaction is very clean and that you're buying that property at market price. If you're selling to a family member, you want to make sure that you're selling at market price because the IRS does look at these. They scratch a little bit below the surface. So you just want to make sure that everything else is very, very clean and upfront. So we just went over forward exchanges, which are the most common exchanges we have. Reverse exchanges are more prevalent now because of the shortage of inventory of property. So in a reverse exchange, you're allowed to purchase your replacement property before you close on your relinquished property. So it allows the client to close on the purchase before closing on their sale. Now there's the same time limit. You have to, within 45 days of closing on your replacement property, you need to identify the property that you're planning on selling. You also only have 180 days to close on your relinquished property once the replacement property closed. So there are advantages and drawbacks to that. Of course, the advantages are you close on that replacement property without contingency. And most people, I've only had in all the reverses I've done, I've only had one individual that needed that 45-day ID period. He wasn't really sure which one of his investment properties he wanted to sell. And so he ended up having to convey that information prior to the end of the 45-day period. Now, in a forward exchange, we hold your money while you're waiting to reinvest. In a reverse exchange, we hold the property in an LLC that is controlled by us while you're waiting to relinquish. So there are some drawbacks in that. Because the property is not in your name once it's purchased, it's in the name of this LLC. You need to be able to acquire the replacement property without, one, having your exchange funds, and two, there are financing challenges because nobody's going to lend, or traditional, I won't say nobody, traditional lenders are not going to lend on a property where you're not on title. So where do you come up with that money? You either have cash on hand, or you have investments that you can borrow against, or you take lines of credit on other property you own, or you go to a hard money lender. Now, this is usually a pretty short transaction, so I know hard money lenders are a little bit painful, but it's not long-term. It's usually 2 or 3 months at the most, generally from the ones that I've experienced, and it's a help to be able to get that financing and be able to have their replacement property. So there are additional costs also. Your average under $1 million 1031 forward exchange costs $1,000 for the accommodation fee. And that covers your one replacement property, one relinquished property. In a reverse exchange, there's a $1,275 non-refundable deposit to set up the LLC and all the costs associated with that. Once we order the LLC and it's approved, we have to pay the annual tax on that. We have to have it audited at the end of the year. So that covers all the associated costs. A 1-for-1 exchange fee in reverse starts at $8,500. Now, when you're looking at paying $60,000 to $70,000 in taxes on your property sale, $8,500 is not a lot of money. Yes, it's a lot in compared to $1,000. Also, we have to take this property and we have to hold on to it. We want to make sure we can transfer it back to you when you're ready. And so we may do an environmental report or request an environmental report. We do a review of the property and look at the history of how it was used. And if it was a gas station or oil land or a previous trash dump, we may ask for an environmental report. That is also at the cost of the exchanger. In all the ones I've done, we've never had to ask for an environmental report, if that makes anybody feel better. We also offer construction or improvement exchanges. We aren't doing these right now. Through the pandemic, there's a shortage of construction workers. There's a shortage of materials. It takes time to get permits now, and you still only have that 180 days to complete construction to use up those funds. What we normally use this for is you can't buy a property for the amount you'd like, so you end up reinvesting it less, and to avoid the taxes, you can do improvements on that home to increase the value and use up the rest of that money and stay tax deferred. This is mostly for, you want to put in a pool, you want to do a deck, you want to gut and redo a kitchen or bathrooms or something like that. You want to make sure it's kind of a sizable thing, but can be done in 180 days. This isn't a situation where you would buy vacant land and build a house on it, because you can't do that in 180 days. About 6 months ago, I had an exchanger that was buying at a lower price, and he wanted to use the rest of his funds to do improvements on the property. And I said, gosh, I think it'll be very, very difficult to do anything within the 180 days. Check with your contractor. He called me back an hour later and said he just heard from his contractor, and the permits alone in California would take 4 months to receive. And then they can start building. So it was obvious that he couldn't do it in 180 days. I don't think any exchange companies, I know our competitors attached to title companies aren't even offering construction or improvement exchanges right now because of the timeline and how difficult it is to get materials and workers. There's similar benefits and drawbacks as there are to the reverse. This is another thing that while we're going through the construction process, we have to hold this property in an LLC, and then we deed it back once everything is complete. They still only have the 180 days. There's still that $1,275 non-refundable deposit because we have to hold it into the LLC. However, these are far more complex, and we do all the disbursements of funds as part of the process. These start at $15,000 exchange fee and increase as more. I think you get 10 disbursements for that, and then anything over that, it's like a 5 disbursement price. I think it's $1,500 for 5 more disbursements. So they are quite costly. It is, however, a way to use all your exchange funds if you're going to end up being taxed quite a bit. And again, right now, this is extremely challenging, so it's not offered, but it's good to know and have that information when things improve later on, a year or so down the line, when things get back to normal. So that's it for me. Does anybody have any questions? I always encourage questions while we're all here together, because then everybody benefits by your answer. But obviously, you're welcome to email me or call me with any questions you have as well.
I have a question for you, Susan, just because I feel like people may not understand, but if you have a residential property that you're currently living in and you turn it into an investment, like a rental property, would it then be viable for a 1031 exchange down the road?
It would definitely be sellable. You want a minimum of 2 years of it being classified as an investment property before you would sell it in 1031 exchange. Now, their tax will make a different idea. We'd obviously go with whatever they decide. Sometimes they like it held longer. And there have been a few occasions where a year, their tax person felt a year was sufficient. The understood rule, because the IRS does not give you time frame, the tested rule is a minimum of 2 years.
Very good, thank you. Any other questions?
I have a question. It's Tammy. Can you hear me?
Hi.
Hi there.
Yes. Hi.
What if my clients does not want to purchase now because the market is hot, and we discussed an option on DST, put the property, put the proceed into a trust, then purchase later on. Would that work?
Yeah, let's talk about Delaware statutory trusts. They're similar to REITs. They're an investment trust, but it's important to note that REITs are not necessarily IRS approved as an investment. Delaware statutory trusts have to meet certain guidelines from the IRS in order to be allowed. And what's great about a Delaware statutory trust is they can help you reinvest to the penny of what you need, because you're buying, that's what I talked about, buying a percentage of something. Now, when you buy a property, you're in total control. When you buy a DST, it's important to note that the trustee is in control. So they make a decision of when they sell the property, and you can sell, and maybe the market is better for purchasing a property when you come out of it. You can go from a DST back into a property. It's also important to note that there's a longer holding period for DST. It's usually 3 to 7 years. You just sit back, they take care of the property, they collect the rent, they send you a monthly check. That sounds fantastic to me, but it's not fantastic to people who like to be in tight control of things, so they want to weigh their options. But DST is a great option right now. I have a lot of exchangers doing DST because they're having trouble finding a replacement property.
Right, and that's exactly what my client and I facing right now. He's selling property in San Francisco, and we're purchasing here, but it's really hard to find a property that would suit to his budget. In regards to the DST and time limit, let's say we're not going to do the 1031 exchange at the moment, and we'll decide to put the money into a trust, DST. There is a time when we can, let's say within a year or so, the market is more affordable. Can we then use the money or the proceeds?
Okay, well, in order to stay tax deferred, even though they're purchasing DST, they still have to go through a 1031 exchange. They still have to have an accommodator.
Yeah, I do understand that part.
In order to stay tax deferred. They can't sell their property and throw it into a trust or a DST without an accommodator in order to stay tax deferred. But yes, they can do, actually the trustee will choose when they sell, and when they sell, they can go ahead and 1031 back into a property. That timeline is up to the trustee. So they want to make sure that because a trustee or a DST usually has a longer hold time than a regular exchange, which is a minimum of 2 years, you want to make sure that the DST is meeting your goals.
Thank you so much for the explanation.
You're welcome. And Joe McGowan had a question that he had in chat. Wanted to read that out. In a forward exchange, when must the additional funds for the replacement property be deposited? So the 1031 accommodator is holding the proceeds from the sale. You're buying a property that's obviously more than what you have in your exchange register, your exchange account. So what would happen is the exchange at closing will send the funds that we have towards your purchase, and then you would wire the additional funds at closing directly to the escrow or title company. You don't need to send them to the accommodator first, and then the accommodator send everything. We would send the funds that we have, you would send the funds directly to our escrow or title for the remainder that is owed. Did that answer your question, Joe?
Yes, it did. Thank you very much. That's perfect. And the same would apply if you were taking a loan on the replacement property. The lender would wire their funds directly in. So that clarifies it. Thank you.
Exactly. Thank you. Is there any other questions?
Hi, Susan. This is Denise. How are you?
Hi, Denise. I'm fine.
Good. I just had a quick question. Does relatively, I know, the IRS federally, is an entity, but what about if you're investing in different states? Do they have different guidelines to go through when you're talking about a 1031 exchange?
Yes, you definitely want to check with each state. Each state has its own tax percentage. So in California, that tax that you may be experiencing may be different than tax in Tennessee. So you want to check with your local state of what that tax ramification would be for you. It's important to note that in Pennsylvania, obviously you can 1031 exchange. It is a federal program, but the state doesn't have to agree. So Pennsylvania, I think, is the only state that does not recognize 1031 exchange for state tax. So if you're in Pennsylvania and you exchange, you will have federal deferral, but not state deferral of your tax. And there I went dark again, I'm sorry. Does that answer your question?
Yeah, and then also if you're, say, like we have investment properties in Texas. And so
Uh-huh.
if you're residing in California and doing a 1031 exchange from one property to another property in Texas, um, that's where I find that it might get tricky.
Okay, so California has what's called the clawback rule. So you sell in California, you buy in Texas, you're still tax deferred.
Okay,
But when you sell that property in Texas and try and 1031 into something else, they want their state tax. The question is, how are they going to know? Yes, there's a rule. They aren't following Texas. They aren't following Georgia. They are, you know what I mean?
right.
So you want to for that, and how do they know? If you're still residing and paying taxes in California, you're going to be
Right,
charged on that income.
Right,
So
exactly.
they could ask for the taxes at that time that you sell that property again, even if you 1031 exchange again. They could ask for you to pay the taxes.
The state
So
taxes on
it's just-
that income.
Yeah.
Okay.
Not federal, just now.
All right. Well,
it's something
yeah, that's really good. I was just concerned about, because we may be doing that next year with one property to another. Obviously we're just 1031 exchanging it right to another property, but I was just curious with the California residing in one and investing in another, and so I really appreciate
Well,
that. That was super helpful.
Yeah, that only means if you sold an investment property in California and then bought in Texas. If you live in California, but your investment property is in Texas, the clawback rule doesn't apply because
Oh, yeah.
you
Okay.
own Texas, you sold and reinvested in Texas. All you have to worry about is Texas. The only time you have to worry about the clawback rule is if you sold in California
And purchased
in another state and then sold that again. They could come back and ask for that tax. Have not had one single exchanger tell me that, oh yeah, boy, California hit me when I sold that property again.
But that's good to know if you're going from Texas to Texas, you're just doing the 31 exchange in Texas, that makes it a little more, it simplifies it a little bit rather than going from one state to the next.
Exactly. Now, if you went from Texas to some other state, you want to check with the state of Texas. Hey, if I sell that property, do you have some? The only clawback rule I know is California. But again, I've never had anybody
Just double
report
check
it, and that only applies when you sell in California, buy in another state, and then sell again and buy in another state.
Right.
Then
That's really, really good to know. Yeah. Cause like I said, it's important to do your due diligence no matter what, when you're talking about properties. But I think that was very clear. Like, they could state tax you, but that's about the extent of it. And usually when you're going from from California to another state. So thank you so, so much.
You're welcome. Also, another thing, if you're doing a short-term rental situation, it's important to check with the city where you're buying, because some cities are making it really hard for people that want to Airbnb or VBRO. They don't want the short-time rentals. The homeowners don't want them. And so they're making it very tough. So they can have parking restrictions that make it terrible for you to rent your property out, or they can come out with additional taxes or something. Always check with the city, check wherever you're going to reinvest to make sure it's 1031 friendly or rental friendly. The other thing, check with your HOAs. I just had an individual 2 days ago call me and say, okay, well, I want to buy this property in a senior community and I want to rent it out. And I said, well, that's fine. Well, the HOA says we have to be the primary resident for 1 year before we're allowed to rent it out. doesn't qualify for 1031 exchange. And it was kind of buried a little bit deep in their rules. I had a guy buy a property in Palm Springs, and the HOA only allowed 10% rental in that community, and the developer bought all of it. So
Wow.
he gets there. It was buried so deep in their rules and regulations that he didn't see it, and his agent didn't know. He bought and he wasn't allowed to rent. He's like, what do I do? To talk to your tax person. Talk to his tax person, and the guy said, we're getting out of there because you're going to go broke paying your mortgage, HOA fees, and property taxes for the next 2 years. You're not going to be able to do it. The IRS does understand that situations change. So there are exceptions to that minimum 2-year hold. You just have to have good tax representation to make sure that if you need to exchange sooner, that they'll argue that case for you. Because it's
Yeah,
not
that
up
was
to the
very
economy.
helpful. And I do like,
Yeah.
just for maintenance purposes and how people can destroy properties, we're definitely in multi-unit and long-term, but that is really good to know for investors we know that do have Airbnbs as well, because HOAs, that's a huge thing. Yeah, some people won't even let them rent out at all. So yeah, it's a really good thing to check into.
And we have that a lot in the desert and also down at the beach, where there's a lot of HOA, not so much in the mountains. Those are usually individual cabins, but if you get that odd HOA type thing, you definitely want to make sure that you go through the rules with a fine tooth comb, or you have somebody do that for you, because you don't want to be stuck with a property that you then can't rent out and you're not allowed to live in. And then you're sitting there emptying your wallet until the 2 years expires. You just want to make sure that you're well versed in the rules for that city, the rules for the HOA. And you also can buy a manufactured home with 1031 funds. However, it has to be permanently affixed to the land. Now, when you're looking at a big piece of land that has a manufactured home on it, it's not so much in question. But how about if you're buying a manufactured home or a mobile home in a park? That's something you really need to research too, because certain parks will allow you, they will deed you a little piece of land that your mobile home sits on, as long as it's permanently affixed. But there are rules that'll say, oh, well, we'll deed you that little piece of land if this is going to be your primary residence, or you're the only one that live here. I had somebody that had that in Carlsbad, California. He bought a beautiful beachfront mobile home property. It was permanently affixed, and then found out later you have to live there. So it just all blew up because he didn't know that. It was kind of buried deep in their rules and regulations that you could rent it out, but you had to live there for a period of time before you did that. So you just want to make sure that you do your research before you buy something, because whatever you buy, you want to make sure that you can rent it out. Are there any other questions?
Susan?
Hi,
Susan?
Jen.
This
Yes.
is Jen. Hello.
Oh, yeah. Hi.
Hi, this is Jen Harris, and I have a question.
Hi, Jen.
Hi. I'm sorry you can hear my dog barking, but in an LLC, and it's a commercial building, and there's 3 partners in it. I just wanted to have you clarify when it's sold, and there's certain percentages that each partner owns in the LLC. Whatever they receive is what they would do in exchange. Is that correct?
So an LLC is not a single member LLC. It's a little more complex. They property is the LLC, and then a purchase property. Now, if they all want their own thing, maybe somebody doesn't want to exchange, they just want to get their cash and go, or they don't all want to exchange in the same property, then they need to deed out of the LLC and distribute their shares and their funds prior to closing on their sale property. That's what's called a drop and swap. So they deed out to do the transaction. They all get their individual funds, whether they want a 1031 exchange or not. They get their percentage of ownership in their funds, and then they move on from there. Unless they're going to go from one property and all decide to purchase the same property in the LLC, they're going to have to do a drop and swap. The IRS doesn't like them, but they don't go after you for them anymore. Now, the state, especially the state of California, may have an issue with that. So again, you want good tax representation when you're doing something like that. If it's simply, we're selling this property, we're keeping the LLC intact, and we're buying this property, you don't have an issue at all. But if they don't all want to go into the same property, or they don't want to hold title in their property in the same LLC, they need to do a drop and swap, and they need to get tax representation to do that.
Okay, that makes sense, because that's kind of what was told to us. And it was getting confusing because two want to reinvest in different properties on their own, and one wants to cash out. So I
Exactly.
see
I
you
have
referred.
the same thing.
Okay.
With an,
So you referred to it
Yeah.
as the drop and swap?
it's called a drop and swap, and you really want a tax attorney in on this to help you, because
Okay.
there's some organizational issues with the LLC that they have to file documents, and they have to have an agreement that they're gonna get out of this LLC, that they're closing out this LLC, and they need an agreement for that. And then of course they need to deed. So they really want tax representation to help them go through that process.
Okay, so then if you're saying that, wouldn't we still need like your company to help facilitate
Yeah.
it? Okay,
You
okay,
need accommodator. You need an accommodator for the 1031, but in order to drop and swap, you want to make sure you've got good tax representation to get all that together. For my part, I know that this is coming, and I'm going to set up the exchange as the individual, because I know when they sell, they're going to have these deeds out of the LLC into their individual interests. It's going to close in their individual interests, and then they move forward. But to set that all up and make sure that they don't have tax ramifications they weren't planning on, they want to make sure that they have a tax attorney set all that up for them. Then title is going to, prior to the sale closing, title is going to record the deeds out of the LLC into their individual interests, and then they're going to close on the sale. They also need to notify the buyer that they're actually selling as their individuals instead of the LLC, which is probably what they set the contract up for.
okay. Okay, that's great. Thank you so much.
You're welcome. Any other questions?
Hi, Susan. This is Jennifer.
Hi.
I'd like to know if a New York co-op can qualify for a 1030 exchange.
A New York co-op, yes.
It
That's how
does.
New York operates. Own shares, correct?
Correct.
You
Yes.
own shares. So your property represents a certain number of shares. Yes, that does qualify in 1031 exchange.
Okay. Even if you purchase it in another state, if you purchase a residential home in another state, it would still qualify?
Yeah, you're selling the shares of your co-op and purchasing a like-kind property, like-kind being real property. I know it's unusual, and I think it's only done in New York. It may be done in you know, someplace like Chicago or something like that too. Usually
Mhm.
really big cities. You know, we don't do that in California. It's an unusual situation that you sell a condo and it's considered real property. In New York, it's shares. And you're going to sell your shares, which are considered real property, and exchange them into something else.
Okay,
That is real property.
all right, sounds good. Thank you.
Yeah, in New York, it takes attorneys. They do their closings with attorneys, so they would set that all up for the exchanger.
Okay,
They'd still need an negotiator, but instead of dealing with title or escrow, we'd be dealing with an attorney in New York.
Very confuses me.
okay, thank you.
You know, I said it probably just adds more confusion and things.
Pardon?
I think that someone just had unmuted themselves. That was a great amount of information, Susan. Thank you so, so much. And thank you, Kim, for bringing this to us.
You're very welcome.
very-
I'm in the process of sending out the present now.
Okay, perfect. And
Great.
then Kim has sent the presentations to all the leadership as well, so we can send it to you guys if you don't get it from Kim directly.
It's a nice primer for you guys to remember what we talked about in the class. But still, if you have any questions, please feel free to give me a call or email me. I'm happy to help out.
Will do. Thank you so much.
Thank you, Susan.